wonderful immigration attorneys. And I'm really, really excited because we're going to have a more intimate conversation this week. Less people, but that always allows us to have great conversations between you guys. So, welcome in, Attorney Ashley Morin, John Veely, and Yesh Rasamiseti. I probably misspelled your last name wrong, Yesh. But I'll go ahead and give the mic over to John. John, tell us about what's been going on in the immigration world this week, and then we'll jump right into EB-2s and EB-3s again.
Thanks, Pierre. I'm here in Boston waterfront. Just arrived a few minutes ago and found a place to be able to do this. So hopefully I'm not too muffled. It's a bit of a hotel lobby thing going on here. But yeah, immigration has been a bit of the highlight in the Republican National Convention. They talked about you know impacting immigration negatively. We've been through the Trump administration before. It was rough on immigration. I think we would see a lot of things curtail some immigration things that we're used to doing right now. I think we'll see the H-1B attacked because it was effectively going to be killed, um, uh, but for Trump not being reelected last time. So I think we might see the entrepreneurship parole, international entrepreneur parole. Sorry, the IEP gets scrapped again. Trump scrapped it last time. Obama had invented it. Biden had resurfaced it. We just did an IEP recently. It's a great tool for companies that can raise money from America to open up their entities and operate them. So we'll probably see that go. Probably see prevailing wages hiked um, without reason, not without reason, but not based on data anymore. There was some discussion on that, creating a minimum wage for uh, a non-immigrant on an H to come in. So any of those things could be really tough on immigration. I don't know that those folks are following that enough, but that was a plank of what happened in the convention last night, and one that everybody in immigration should be aware of. So those are my thoughts. Love to talk EB2s and EB3s and see what Yesh and Ashley have to say about
Very well.
immigration.
Going back to the RNC, one of the things that have been highlighted recently, which I don't know if you guys have looked into it, but the Trump administration or the campaign is saying that they would be willing to make it where those that are vetted, anyone that graduates university in the U.S., that they'd want to do it where they can have a pathway to a green card right away. Did you hear about that at all?
No, I've just heard negative things, and I've heard a lot of racist negative things against the presidential candidate whose wife is Indian, and that has sparked at least part of the party's ire. So look, I honestly, that administration was in power just one administration ago. If they wanted to implement something like that, they would have. I don't think that would happen, honestly. And um, personally, I don't trust them to do positive immigration things because they didn't before. Why would they now? So uh, maybe they're trying to pick up votes. Maybe I'm being a little too sinister about it, but I don't think. And unfortunately, we have a very very low unemployment rate right now. We need immigrants. And more than we did 4 years ago. The baby boomers keep aging out, and there are jobs being undone, and we have a very very low unemployment rate. So if we make it hard on immigration, or we deport a million people, like I heard promised, it's going to hurt the American economy, and it's going to leave jobs undone in America. So I'd love to see something where there was an automatic green card, but I don't see that coming out of that party. And I don't see it coming out of either party. Honestly, it's too much of a hot button topic on both sides.
Excellent. Well, thanks for that feedback, John. Let's jump right into
Sure.
it. So I know we have Yesh and Ashley with us. We've covered EB-2s and EB-3s in the previous 2 weeks. What are your thoughts about today? Are you guys thinking that EB-2s and EB-3s are still a topic that you'd like to chat about and speak on further, or is there a new visa type that has your attention?
Yeah, I think let's keep going. I thought we had a really good conversation last week, and I don't think we finished. I think there's a lot to talk about on this subject matter. Love to hear where Ashley wants to go with it, who was leading a lot of that conversation last week, and maybe jump in, Ashley, and
Yeah.
take it from where you think we left off. And
Yeah.
Yesh and
So
I
I
can,
think
jump in.
last time we talked about the prevailing wage, how to craft a job description, some of the
Right,
pitfalls that can come with that. Um,
right.
and so I think we're probably at the recruitment stage. Um,
Yeah,
So there's two different ways that you have to do recruitment. There's mandatory recruitment steps that are for any type of position. And then if the position is a professional position, which is a position that requires at least a bachelor's degree generally, or the foreign equivalent of a bachelor's degree. And I think we kind of went into um, that equivalency and how you have to come to that conclusion that it's equivalent. It has to be based on education only, not education and experience. Um, so if it's a professional position, then there's additional forms of recruitment that have to be done. Most of the ones that we do are professional, so we do those additional forms of recruitment. You can choose three, and I pulled up the list because I don't know the whole list off the top of my head. Which is there's a company website, recruiting them applicants at a job fair, engaging in an employee referral program, on-campus recruiting at a local college, place an advertisement with a job search website other than the employer's website, place a radio or television ad, place an ad on the campus of a local college, place an ad with a trade or professional organization, place an ad with a local or ethnic newspaper, or place an ad with a private employment firm. And I've done a lot of these over the years. I think the ones that are the most common are the placing the advertisement at the company's website, um, and doing the job search website and the radio or television ad, generally radio.
Mm,
Um, and I think something that's interesting about Perm is that it seems that they haven't updated their forms of recruitment since Perm was created.
right,
I don't think that many
right,
people are looking in the newspaper anymore for a job. So when we're talking to
right,
employers and we tell them about the forms of recruitment that we're going to do, where we're going to do a radio ad and a newspaper ad, they're like, well, why wouldn't we just be doing an Indeed ad or a LinkedIn ad? Um, so that's kind of an interesting part of recruitment. But recruitment generally, the longest running form of recruitment, which is mandatory for all professional and non-professional, is the SWA or State Workforce Agency job order. And that where you post that will depend on the state where the job is going to be. The State Workforce Agency websites are pretty outdated. They can be a little bit hard to navigate. But that has to run for 30 days. So generally, that's the form of recruitment that we would want to start first because it's the one that has to run the longest. The job posting
right,
notice, which is posted at the employer's work site, only has to be posted for 10 days. And then the Sunday ads are just 2 consecutive Sundays. Um, so those run much shorter. So as long as you can start that SWA job order first, then you can do all the other forms of recruitment within that 30 days and it keeps your time down, because you have that 30 days that the SWA job order is going to be running, and then you have an additional 30 days for the cooling off period. It says reconnecting on my screen. Can you guys hear me?
We hear you and we see you.
yeah,
Okay.
yeah. You're fine. It's doing it well.
Okay. So then there's a 30-day cooling off period, and that's the period of time where applicants may or may not be coming in, and the employer has to vet those applicants and determine if they are qualified. And if they are qualified according to the job description and the requirements that were listed, then they would have to interview them, and if there's nothing that disqualifying, hire that person. Um, generally with the forms of advertisements that perm requires, there aren't an overwhelming number of applicants, because like I said, I don't think many people are looking in the newspaper or on the radio for a job, but you know, there are applicants, and it's very important to document that process. How many you've received, if they were disqualified, the reason that they were disqualified, because you know the DL will look into that. So then after the cooling off period is over, and you've collected all of the applicants and put that in your report, then you'll be ready to file the ETA 9089, which is the perm or the labor cert. Am I going too fast? Does anyone have anything to add?
So let's, yeah, I wanted to, that's a great laying out of the process. So what we should probably do is talk about strategies around that, right? So how can attorneys help companies in this? Number one, it's companies, right? Beneficiary comes to us and says, I want to get an EB or EB-3. It's fine. Introduce us to your company. Just step out of the way, because the person that wants to be hired, that the company wants to hire, if there is a person, cannot be involved in this research. It's tainted it. They cannot be the person that receives the resumes, for example. They stay completely away from it, and they don't know that a lot of times. They also can't pay for it, and the company has to pay the advertising. So a lot of things that go into this are a company that's not all that interested, or you know, it's really the driver of it is the employee, and you say, look, you got to find somebody in the company. Sometimes the companies are kind of small, and there needs to be somebody on the company that's trained. The company can't even refer it totally over to the lawyers. For example, the lawyers can't be the recipient of the resumes. The lawyers can look at the resumes, but the company has to have the receiver of it, and then go to the lawyers. They obviously can go to the lawyers. You think these people need to. The strategies come in first. Talked a little bit about that. I want to put numbers in it. What I mean is that instead of just saying experience in a type of technology or whatever you're doing, you know, 24 months or 2 years would give a number. So if somebody comes in with 23 months, they're disqualified. Remember, this process is an interesting process because you're really putting ads out into the market. And the reason that these ads are going to the market is that we're proving that there are no Americans willing or able to do the job. Able's the key here. And so we're testing the job market and saying, look, the test, and that that's why certification specifics on the amount of experience and what that experience is, right? And that's why it's so important for a lawyer to be involved in this, because if you just run the ads that you typically run, they have problems too easy for someone to meet those. That's come in and we can help. So there's some thoughts on that. Yes, do you have any strategies or thoughts around? You do a lot more on the H side, but those often lead into the clients because to the H to perm sort of transition. Yes, can you? Oh, there you
I
go.
heard my name, but everything I heard was very choppy, so I don't know what question was asked.
Oh, I'm sorry. I was asking, we know that you do a lot more H's than perms, but there's such a transition between the H and the perm. What are some of the strategies that your clients use, or things that might come in the, when you're looking to make that transition from H-1B to perm?
I believe we spoke about it. I think we touched about it briefly last week. You know, if you're working with the same employer, and you want to go you want to file the perm, you can't really use the same employer's experience. And so that's something that we might have to consider when we're moving from the H process to perm, to see if they move into a different job. And then if we can finish the deletizer analysis at that point to see if it's a little bit slightly different, or if we have to find experience through a qualifying experience through another employer. But that's something I really wanted to see if we could touch up on this week, is the deletizer analysis.
Yeah, and I think another big thing for
Sure.
you doing a lot of H-1Bs is probably timing and when they need to get that perm filed by, so that they can use that I-140 approval to continue to get extensions.
Typically by the end of the 5th year, or your 5th year anniversary of the 6 years that you have, is when you should have filed or started that application. Just because it takes so long. I think the PWD, or the prevailing wage request, is taking around 6 to 8 months.
6 months, yep.
6 months, right, on average. And then you have the 63 days recruitment and cooling off period. And then you're at that point, you're pretty much running out of time if you're starting this on the 6th year. There's no way that you could get it done. So usually by the 5th year, we try to say.
You're right, but you're missing one thing that's really important nugget for them to remember. That's why you need to start by the 4th year, because if you don't file the labor cert, which is the third thing to do, remember then there's the recruitment. The labor cert is the third thing, and you're looking at about a minimum of 9 months before you can file it. So if you start the prevailing wage today, it's going to be 9 months before you can file that. If you don't file your labor cert by the last day of your 5th year, can't extend your H-1B beyond the 6th year. So you can extend your H-1B beyond the 6th year if you filed the prevailing wage prior to that 6th year. I'm not prevailing, the labor cert. That's something that's lost a lot. And so H-1B attorneys have to be very, very wary, cognizant of the labor cert issue, because especially if they're dealing with people from countries that have long wait times, like India, which is probably 70% of H-1B workers, then they need to know with those late priority dates that they're going to need to extend the H-1B beyond that 6 year to keep them employed, right? And sometimes that's 12 or 15 more years, and they're on the H-1. Now, if they file the I-140, which comes after the labor cert, we haven't talked about that yet. They file the I-140, right? Then that takes about 6 months too. When that's approved, they have to wait, if you're from a country with a priority date that's not current, like India and China and the Philippines. Then their spouse can get an H-4 EAD, right? So for H attorneys, really, really important to tell their corporate client, file the green cards, so that your employees can get a work authorization when the I-140 is approved. So this whole process is really between 1.5 years and 2 years to get the I-140 approved. And for certain countries, they're going to have to wait a long time before they can adjust. But getting that I-140 approved gives their opportunity for their spouses to get a work authorization. The other spouses under the H get that. H-4 EADs are based on that. So H attorneys need to know certain things for perms, even if they're not doing perms. And one is, you got to file the labor cert before the 6 year. And if you get the I-140 approved, spouses can have H-4 EADs. So thanks for bringing that up. Yes, that was a really big.
And I think something else that's important to note is that 9 months that you were pointing out assumes that you have no problem creating the job description. You have no problem getting the experience letters. Right. All of those things can slow the process down on the outset, which can make it take longer depending on, how long it takes the beneficiary to come up with that.
When do you think someone should start the green card process?
I think as you said, in the 4th year would be the safest.
Yeah. So maybe if you just want to put a date on it, if you get to year 4, What that means is that your H-1Bs have been extended once, right? Because H-1Bs are 3-year increments. You've now done your extension, and by the time you get to the first day of year 4 is when you need to file your green card, so that you've got a full year to have some issues, right? Which all sorts of issues can come up, right? The prevailing wage may come back with a problem. The recruitment may, here's a really big problem. Somebody comes forward, and the company can hire anybody that comes forward, and that will go forward. But what if 100 people come forward, right? Then they're going to have to start over. And that start over, what, for 6 months? Is that right, Ashley?
Yeah.
Yeah, so that's a rule of thumb, I think. I'm not sure if it's a regulation or not. Maybe you do. But if somebody comes forward, you can't just start the recruitment the next day. Again, you got to go all the way and do it all over, and usually have to do the prevailing wage again. So it's going to back you up a lot. So things can happen. So if you know you want to hire somebody, do it. We have a lot of our clients that, especially those in the H-4 EAD realm, that almost immediately after they get the H-1Bs approved, they're putting in the labor search, and that's because that's what the market demands. If employers aren't doing that, they're going to lose those employees. So we want to move on. Okay, so that's labor cert. Ashley, take us to what happens after the labor cert's been filed. What can happen, pros or cons, and what's the next step after that?
Yeah, so the labor cert is extremely important. You want to make sure that everything on there is completely accurate, from the dates that all the recruitment ran to the exact wording that's, in the PWD and things like that. It all has to match, and they are very closely checking. So after that is certified, which is, I think, taking about 8 months, then you would be eligible to file the I-140 or the immigrant petition. Once the labor cert is filed, that's going to give you your priority date. The date that it's filed will be your priority date. When you eventually get your I-140 receipt notice, it'll be listed there. That priority date is what you would take, and you go to look at the visa bulletin. You can find that if you Google visa bulletin, it will come up. But to read the chart, you would want to go down to employment based, figure out if they're using the dates for filing or the final action dates, read the appropriate chart using your country of citizenship and the category under which you are applying. And then your priority date must be before the date that's listed on that chart, unless it has a C, which means current, which means if you are in that category and you have that country of citizenship, then you are eligible to file. So, and eligible to file the adjustment of status or the I-485. So some people can file their I-140s and I-485s concurrently, but a lot of people, especially people from India, the Philippines, China, Mexico, oftentimes have to wait a significant amount of time.
So tell us some reasons labor cert can be denied, like specific instances where they do it, and what do they do? What do they do if they don't like it? What's the device that they send out if they have a problem with it?
Yeah, so they'll send out a denial. They give you the opportunity to either reopen it and have them reconsider it, or you can take it right to the I'm blanking, BALCA, and appeal it. General best practice is to have them reopen it and reconsider it first, because then you get kind of a second bite at the apple. They might redetermine that it can be certified. If not, then you still have the option to appeal it. A lot of the cases that go to BALCA don't do. It's a hard thing to get passed and get it approved. If that doesn't work, your only option would be to litigate.
Audit?
Or they can issue an audit. Yeah, so they can issue an audit, and well, an audit can be about a lot of different things. Personally, I've seen it most with recruitment, where they want you to show all of your recruitment. They want you to show every, resume that you've collected and prove why you disqualified
Right.
those people. It can be, dealing with
'Cause
audits can be arduous.
You don't have to give all recruitment file, right, for 5 years. Isn't that the rule? So you're not sticking in your recruitment results with a typical labor cert. Only if they're audited do you then show them these things. Is that correct?
Right. Yeah. So the labor cert will list all of the forms of recruitment that you did and the dates on which you did them and the newspaper that you placed the ad with. But it won't include proof of this. But it's very important that you maintain proof of this in the case of an audit. And generally, your attorney will put together an audit report for you that you should keep on file for, 5 years, in case of an audit. So that would include the newspaper tear sheets that show that the ads were run, the radio ad tear sheets, the proof that you posted the job at on your website or at your workplace, just proof of every form of recruitment that you ran. And then during the cooling off phase or the recruitment phase, if you've received any applicants, you should hold on to their resumes and put that in your recruitment report, and hold on to that in case of an audit. Did that answer your question? You were breaking up a little bit, so I wasn't sure.
Internet. So we audit and we get it approved. Now what?
Once it's certified, then you can file the I-140 or the immigrant petition, depending on your country of citizenship and your category. If you're an EB-2, EB-3, well, there wouldn't be EB-1 because they don't have perm. So if you're current on the visa bulletin, then you could also concurrently file your I-1 or I-485 or adjustment of status application and the derivative applications that go with it. The I-765, which is the application for work authorization, and the I-131, which is the application for advanced parole. And interestingly, those used to not have additional filing fees, and as of April of this year, now they do, and they're kind of significant.
Yeah, for sure. Reasons that an I-140 can get denied.
Oh, there's a lot. So an I-140 can get denied. Big one would be ability to pay, where they want the employer to show that they have the ability to pay the salary that's listed on the labor cert and determined by the prevailing wage determination. That salary can be greater than what the prevailing wage was determined to be, but it cannot be less than. And the employer would have to prove that they can pay the person that. The easiest way to prove it is to show that you already have been paying the person that and submit their pay stubs. But other ways to show it would be tax returns, the employee wage summary. I forget exactly what the form is, but yeah, basically showing that you have the funds available to be able to pay this person the wage that you say you're going to pay them when they receive their green card, because you're not obligated to pay them that wage until they receive their green card. But they can ask you to prove that in the future, you will be able to pay them that wage based on what you're doing now, which is a little bit, it's a little bit, yeah.
I mean, because some of these people will not get their green card for like 15 years.
Exactly. Yeah. So you might not have to pay them that wage for 15 years, but you have to prove that you're able to do it now.
Okay. So when you're talking about ability to pay, one of the rules is if you are paying them the prevailing wage, that's an automatic win. If you're not paying,
he's gone. Right, Pierre? I think he dropped off.
Yes, we just lost John.
That's okay. That I was kind of saying that maybe he didn't hear me, but if you can prove that you could submit their pay stubs and show that you're already paying them that prevailing wage, then that's the easiest way to win that kind of RFE for an I-140. So that's one of
RFEs really common. Do you think they're across the board more common?
RFEs are
can you guys
kind of
hear me?
Yeah.
Sorry, I know my internet is bad here, the question I was asking is, you were talking about ability to pay, and I think I'm not sure if my statement was made, but if you pay prevailing wage, then you've answered the ability to pay because you're actually paying it. If you're not paying the prevailing wage because you know you're not going to have to, and you got them on a lesser amount, what can you use to prove that you can make the prevailing wage?
Yeah, you can show your tax returns that show how much money the company's brought in. You can show your employee wage summaries to show all the wages that you're currently paying, and that this would be, essentially a drop in the bucket, especially if it's a larger company. You can show what their stock is trading at. You can show there's a lot of different things that I've used. Those are the main ones. Yep, lines of credit, profit and loss statements. There's a lot of options.
Yeah.
Isn't it different
so
for like smaller employees and go ahead.
Yeah, it's the bigger the company, the easier it is to prove that they have the ability to pay. The smaller the company, to show that, because they don't have 1,000 employees or publicly available annual reports that show how much they're making. And maybe their taxes don't show that they have that much revenue, and you would have to show that, they.
One of the things that I think new attorneys or attorneys that don't have that they can make, which is one of the worst to have to experience, is taking the employee's word for it that they have certain experience, right? And they go, well, I've got years experience. I worked at this place and this place, and I'll get that later when I do the I-140 instead of at the very beginning. That's what we do. Our rule is get your experience letters to before even put in the prevailing wage, because the nightmare is when you're in I-140 and you're now not or a year down the road, and they go, oh, I worked part-time at another job, or oh, I can't get a letter from my previous lawyer, and now they don't meet the requirements that you set up, right? You have eliminated your own client from the case because you put in a requirement that they couldn't prove. So proving the requirements at the beginning are critical.
Yeah, definitely proving the requirements at the beginning are critical. You're breaking up a little bit, but I can kind of take it from there. Because oftentimes when you get to the I-140, the experience that they're using to qualify can be, a decade old, 12 years old, 15 years old. And that company might no longer exist, or their contact there is no longer there. They can't get an experience letter or anybody that can, attest to what they were doing while they were there. So it's better to get all of the letters at the front end than to wait till you get to the I-140 stage, go through all of this, the whole process and all the time that it takes and all the money that you spend on recruitment, just to get to the I-140 phase and realize that you've disqualified your own employee because they do not meet the requirements because they're unable to get an experience letter for employment that they said they had.
Yeah, absolutely. That's a nightmare for any attorney that goes through it, because your client probably going to ask you, it's your fault and you eliminated them, and we want you to do it again. We want you to do it for free, and we want you to pay for our advertising, which is not inexpensive. Going back to advertising and it's expensive, you made the mention the want ads anymore of the major newspapers, but because that's a requirement, almost every job in there is a green card job, and because of that, those advertising fees are very expensive these days. There's some strategy that companies can use to save money on advertising costs.
You were breaking up. I think that you were asking what are some strategies that they can use to reduce advertising costs? Is that right?
Yes, thank you. Yep.
So one way is to work with a advertising agency. They work with a bunch of different newspapers, so they get a reduced rate for these. A lot of the newspapers won't even let an individual employer place the ad. They only work through the ad agencies. I had that come up rather recently, which I didn't know that before, so that was surprising. Um, but working with the ad agency will get you a discounted rate. Also, something that you want to take into consideration when you're crafting the job description. If the job description is 3 pages long, and they don't want to cut it down at all, everything is essential and they need to keep it all in, then they need to know upfront that their recruitment stage will be exorbitantly expensive, because it is charged by the character or the word. Um, so if you walk a tight line there because you want to include enough that the DOL doesn't determine that it's too vague or generalized for them to provide the prevailing wage, but also not include overly much and then have to pay all those additional fees for recruitment.
Great. So how are we doing on time, Pierre?
Very well. Well, we're 10 minutes past our time, but you guys were having such a good conversation that didn't want to cut you off. Thank you very much for today's conversation. I definitely think that it seems like green card jobs are keeping these advertising departments of these newspapers alive, which is
Right.
amazing. It really,
Newspapers
really is.
alive. Yeah.
Yeah.
Yeah, it's cool how everything works
Save the New
together.
York
It's like,
Times.
look, it's helping the U.S. economy in a way that no one ever talks about. So that's really, really cool to look
Right.
at. And I just want to ask, how can someone get in conversation with you guys and your firms? What's the best way? Because I truly, truly think there's so many people watching that could qualify, or could know someone that qualifies. So this seems to be a very overwhelming process. Can you, if someone works with you, can you make it a little bit less overwhelming? Can your team put it in a way where it's less to take in? Because it feels like a lifetime project.
Honestly, I don't think you could do the labor cert process without an experienced labor cert attorney. Just the attorneys that do the other stuff have troubles with it. There's too many moving parts. You got to get them right. If you don't, the whole thing fails. So, yeah, I'd heavily suggest talking to an attorney, and welcome to call us for a strategy session. If they come to information at vlielaw.com, that's the word information at VELIELAW.com. You can set a strategy session with any of us, and or call 405 310 4333, or go to our websites, vlielaw.com or onlinevisas.com.
Beautiful. Thank you so much for being here. Three wonderful attorneys, and I had a great, great conversation. We'll see you next week at the same time, and have a wonderful weekend.